Well, hello everyone, and thank you for being here. I'm Lior Samfiru, the employment lawyer, and you've reached the live stream session. This is your live stream session where we talk about employment law and workplace rights. Again, I'm Lior Samfiru, the employment lawyer. I'm one of the founding partners of Samfiru Tumarkin LLP. You'll find our firm across Ontario, BC, and Alberta. And right now, right here at this time, I am live answering questions. I'm here not just to talk to you about things that I want to talk about. I'm here to talk about things that you want to talk about. If you're facing a workplace issue, a problem, an issue with your boss, losing your job, changing your job, medical leaves, whatever the issue is, I want you to ask a question. I want you to tell me what's happening and give me that opportunity to help you. This is the point here, that you leave here better off than you were coming in, with more knowledge, with more power, with more information. Again, I'm Lior Samfiru. They call me the employment lawyer, and I'm here talking to you live about workplace issues. There's no bad questions. There's only answers, there's solutions. There are things that you can do. And I can tell you that because our laws across Canada, our employment laws, are some of the best employment laws anywhere in the world. We have them right here. And I can tell you what they are, and I can tell you what the law can do for you and how the law protects you, gives you rights, gives you options. You have options if you lost your jobs, and you have rights. You have options if your job has been changed, if you're put on a temporary layoff, if your boss is not treating you properly, if you're harassed or discriminated against. All those issues, all those things we can address, and you can ask a question right now. It's so easy to do. It's the simplest way to get some help, to get some answers. Type in that question on that box on your screen, hit enter, and it'll just pop up on my screen. I'll read it and I'll answer it. That's how easy it is. Now, before I get to answering questions, I want to give you some other contact information. If you want to connect with me and my team off live stream, off social media, you want to have a private chat, very, very, very easy to do. All you have to do is go to employmentlawyer.ca. You see that address over here, employmentlawyer.ca. Phone numbers there, email addresses there, all the contact information you can ever need is right there. And of course, while you're there, you can also read up a bit more about employment law and workplace rights and give yourself some more knowledge about this very important topic. We all have jobs, right? We all work, so we need to know the laws governing our job. You shouldn't just go to work not knowing what your rights are, what is legal and what is illegal. What are your rights? What are your obligations? What your employer can do? That's what employment law is all about, and that's why I'm here right now to tell you and answer your questions. Man, I've been seeing a lot of stories in the media about employers letting people go, whether it's Starbucks or Scotiabank or many other employers across the country. If you're one of those employees and you've been affected, you got to know what your rights are. Ask a question right now. I'll tell you, been contacted by these employees many times over the past number of days. We're helping them. I want to help you as well. All right, I think we got to start answering some questions right now. If you're just joining, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, live, answering your questions. All right, let's get to it. First question out of the day, always thank you for that, comes to us from YouTube, and it's from Saeed. Can I be fired if my disability affects my work performance? The answer is no, as long as your employer knows that your work performance is suffering because of a disability. If they don't know that, so if they only think, well, you're just not working hard enough, you never told us you have a disability, we just think you're not working hard enough, potentially, yeah, they can let you go. But if you tell them and you provide something from a doctor saying, here's what I'm struggling with, here's the accommodation that I need, or here's how my performance may be affected because of this, you cannot be let go at that point. You're protected. Your job is protected. So some people think, well, I just don't want to share that information. Well, if you don't share that information and your employer doesn't know, your employer may simply think you're just not doing a good job. Well, I don't want you here if you're not doing a good job for no reason, so I'm going to let you go. So that's what you have to understand. Now, of course, if you're going to tell your employer, you don't have to tell them what the condition is. You don't have to tell them what the disability, what the medical issue you're dealing with is. They just need to know that there's a medical issue. whether it's you're suffering from depression, or you're suffering from ALS, or you're suffering from a bad back. Ultimately, that is private and personal information. You do not need to share that. But what you do need to tell them, especially if it comes with the doctor's note, is that there is a medical issue that's going to impact your job. If your employer at that point, say, does anything to you, punishes you, puts you off work, doesn't treat you well, I want you to call me, okay? You can contact me, and you should contact me right away. And of course, to connect with me, very, very easy to do. I just now want you to go to employmentlawyer.ca. See that address over here, employmentlawyer.ca, and all the contact information is right there. Great question, Saeed. I'm sorry you're dealing with this concern, but I'm here for you if you need some help. Now you know what to do and what not to do, so use that information. I hope you guys see how easy it is to ask a question and get some answers. And if you're just joining us now and wondering what is this all about, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. And I'm here live, answering your employment law questions. It's called a live stream. But yeah, because it's live, and you get to have me here for the half hour answering those questions that you have. So ask them. I see some questions have come in. I'm going to continue answering them, but I want your questions as well. Please do that. Do it for me. Do it for yourself. Do it for others that are watching and listening, because when I help you, I'll probably be helping them as well. All right. Next question today. It's from Tim. Tim says, I'm 58 years old. I'm a 58-year-old employee with 37 years of service. All the employees at the company received a notice of layoff for October the 27th due to tariffs and business. I am hesitant to sign this. Can this lead to more layoffs? Should they communicate the length of the layoff? What should we do? Okay, great question. So what you're talking about here is what we call a temporary layoff. In other words, the company is saying, we're struggling, so we're going to put you off work for a period of time. So assuming this hasn't happened before and they haven't put you on a temporary layoff, it means that the company does not have a right to do it. So here's your options. Option number one is you sign, you accept, you sit at home and see what happens. That's option one. Not a very good option, but that's option one. Option number two is you can choose to consider this layoff, this temporary layoff, as a termination of your employment, and then force the company to pay you severance. I can tell you that for you, after 37 years of employment, Tim, this would be right around 2 years' pay, 24 months. That's what you would be owed. So the decision is, do I sit at home and accept and see, maybe they call me back, maybe they don't, but in the meantime, I'm just sitting there, or do I treat this as a termination and get severance? I want you to think about something else. If you decide to accept this layoff, and let's say 6 months down the road, they call you back to work. The problem is, if you've accepted this layoff, you've now given the company the right to do it again. And the next time they put you on a temporary layoff, you may not be able to do anything about it at all. So you could end up being in a situation where you work for a few months, you're off for a few months, back and forth, back and forth. And why? Because you let it happen that first time. So you and your colleagues have to decide what is better. Do we sit at home or do we get severance now and move on? If you want to proceed with the severance option, with the termination option, call me before you do anything else. Don't talk to your employer. Don't sign anything. Call me before you do anything. My contact information, you can get that. You see that over here, employmentlawyer.ca. Again, employmentlawyer.ca. Very, very important. So that's what I want you to do, and hopefully that helps. Tell your colleagues as well. Same with you at home. Many people think that an employer is allowed to put you on a temporary layoff. For the vast majority of people, that's simply not correct. For the vast majority of people, a temporary layoff is not allowed. It's not permissible. Okay? So I want you to remember that. And for most of you, that's considered a termination. Thank you. Great way to start today, guys. And I want more questions. If you're now just joining, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP, and I'm here live with you, answering your questions about employment law, talking to you about your legal rights on the job, telling you what you should be doing or not doing if you're facing a workplace issue. So take advantage. Man, I'm not always here, right? So take advantage of me being here and ask me your question. Let's have this conversation. So fantastic. Love the question. Let's go next question to Jax. Jack says, can I refuse to do a task I believe is dangerous without being fired? So no, you're allowed to refuse unsafe work. If you're telling your employer, I'm not going to do this because it's unsafe, your employer cannot fire you. Here's what your employer is allowed to do. If they fix it, fantastic, then you can go back to do the work. If they can't fix it and you still refuse to do the job, they have to call in an inspector from the Ministry of Labor. They have to, who will then review it and determine, is it safe or is it not? If the inspector says it's safe, then you have to go back to work. If the inspector says it's not, then your employer is going to have to fix it. But in the meantime, while this process is going ahead, you cannot be fired. You cannot be punished in any way, shape, or form. I'm going to take it a step further. Not only do I think you can refuse unsafe work, you should refuse unsafe work. You don't want to be hurt. You don't want to hurt someone else. So refusing unsafe work is a right that every employee has, and I'm going to say you should be doing that. Okay? If your employer does anything to you, I want you to reach out to me. Employmentlawyer.ca is the way to go. And I see Jax has a follow-up question. He says, if I work construction, are temporary layoffs allowed, like in the wintertime? So if you're doing a job that doesn't have work in the winter, you work in gardening or roofing where there's no work in the winter, there's an implied term that you can do, that you're going to be off in the winter and you can be put on a temporary layoff. But if it's a job that goes year round, but your employer just decides to put you on a temporary layoff, that's not allowed. So some jobs, by definition, you expect to be on a temporary layoff in the winter because you can't do the job in the winter. That's okay. But if it's a job that you can do in the winter and you've done it before, but they just decided this year to put you on a temporary layoff, no, that's not allowed. So hopefully that makes sense. Jack's follow-up questions, I'm still here. Please ask them. No, be bashful. It's great to have that. And if you're just joining us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. I have some more questions to answer. I want your question as well. And don't be bashful. Keep me busy. Keep me on my toes. Make sure that I'm hopping here. Sometimes I get questions right at the end of the seminar, at the end of the session, and I don't get to answer them. And then people say, well, why didn't you answer my question? Well, because I didn't get it in on time. You have the opportunity right now to get it in on time. You have time. If you ask a question now, I promise you an answer during this session. So please take advantage. Don't wait till the very end. All right, let's see. Our next question today, this one comes through Reddit, and it's from Dan. After my employer eliminated my role in BC last year, I was relocated to Ontario for a new position, which included a clause stating I'd need to repay relocation costs if I left within 24 months. But I never signed or formally accepted that condition. A year later, I've resigned and am being asked to repay about 25% of the expenses, which I cannot afford. I'm wondering if they have any legal right to enforce repayment without a signed agreement. So it's not a question of whether you signed it. It's a question of whether or not they can show that you accepted it. So if, for example, if they sent you an email saying, we're going to relocate you on the following basis, including you having to repay, and you respond saying, yeah, that's okay, then you've accepted it, and they can, of course, enforce it. But on the other hand, if you've never accepted it, if they just sent it, but there was never really any back and forth, no way to show that you've accepted it, then they can't enforce it. So the signature itself doesn't do everything. A signature is just a way to show that there is acceptance. But there's other ways to show. An email saying I accept is probably even better than a signature. So generally speaking, your employer can only enforce you giving the money back if you show that you've agreed to do that. So they have to prove that agreement. And one way to show is that they sent you an email and you said, yeah, that's cool, I'm good with that. So hopefully that makes sense. And by all means, if you don't think you've accepted and they are still demanding payment from you, let me know. I'll get them off your back. Once they hear from me, they'll back off and say, fine. So, something to keep in mind. But best advice is this, for future, for you and for anyone else. If your employer sends you an email saying you agree to this and you don't agree to it, say so. Sometimes being silent can be considered acceptance. So if I were to get an email from my employer saying, if you leave within 24 months, you have to repay us, and I'm not okay with it, I would say, no, I'm not okay with that. Okay? If I just ignore it, that's not a good idea, right? So something to think about and something to keep in mind. But of course, I'm here if you need help. If you have any questions that you need to follow up on, I'm here to ask me and I'll answer. Now, before I continue answering more questions, I want to go to a tool that I always talk about because it's so valuable, and that is the severance calculator. If you want to know how much severance you're owed, if you want to find out what you should be getting if you lost your job, you got to check out the severance calculator. It's free and anonymous. How do you do it? Easy. Address is right here, pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. When you go to that website, you click at the top on the severance calculator, and right there you have it. You answer a few questions, and it's going to assess for you if you're owed 8 months, 12 months, 24 months severance. Completely free and anonymous. I've said that. You need to know that. Over 2 million Canadians have used it. It's so easy to use, and it's accurate. Okay, it gives you what you need. And people ask me, well, I don't need that because I get a week per year or I get 2 weeks per year. Nonsense, not even close. That's wrong. That's false. That's why I created the severance calculator, because it's not true. Okay, you need to use it to find out exactly what you're owed. And that's why you go to pocketemploymentlawyer.ca and use the severance calculator. You may be shocked by the amount that you're owed, but that amount is accurate. There's no typo. There's no bug in the system. That amount is correct. So again, pocketemploymentlawyer.ca. And if you want to, and only if you want to, you can also contact me directly from the severance calculator. All right, now that we know that, let's answer some more questions. By the way, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP, live here with you right now, answering questions. I see some questions have just come in. You guys are awesome. Keep them coming. You still got time. I still got time. So let's make sure we get your questions answered today so that you leave here with all the information that you need. All right, let's see. Next question, ask yours, is from Omar. My boss regularly makes racist comments in the office, but management says it's just his sense of humor. My God, what legal options do I have? Impossible, nonsense, ridiculous for the company to just let them do that. That's horrible. That itself could be a human rights violation. Here's what you do. I want you to send an email, because it needs to be in writing, okay, to management saying, I've already told you about this, boss. You haven't done anything. I'm asking you again. He's made these comments. Here's what the comments were. Please talk to him. Please do something about it. If they deal with it at that point, fantastic. If they don't deal with it, if they ignore it, if they tell you, oh, it's just a sense of humor, you have them on a human rights violation. You have them potentially in a constructive dismissal. It's illegal, and it is a big deal. Okay, no one should be subject to racist comments, racist behavior in the workplace. Unacceptable, full stop. So I want that to be there, to be a record in writing. I don't want your employer later to say, oh, you never told us. We didn't know. We don't remember anything. That's why it has to be in writing. Send them that email saying, I've already told you about this. It's not the first time, employer. I'm telling you again. All right? Please deal with this. Give some information. Tell him what he is saying, and maybe give him some example. He said last time he said it was last Tuesday at this meeting. Give him as much information as you can. Your employer has to take it seriously. They have to deal with it. They can't ignore it. It's a big deal. If you're in that situation and your employer still refuses to deal with it, I want you to connect with me immediately. Okay, right away. You can reach me, of course, through employmentlawyer.ca. Again, employmentlawyer.ca. Thank you for that, and let's make sure that behavior does not continue. Unacceptable. All right, thank you for that question. I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. Some more questions have come in. I'm just going to continue answering. T has our next question. My boss always makes weird, suggestive comments / jokes towards me and some of the other girls at my work, and we're unsure of what to do. Okay, so very similar to what I just told Omar. I want you, and ideally this can come from you and your colleagues together, but certainly from you in writing, send an email to HR, to the right person, and whoever the right person is in your workplace, and tell them about it. Okay, you need to tell them about it. I know it's uncomfortable, but you need to tell them, here's what's been happening. We don't think it's appropriate. It's making us uncomfortable. Please deal with it. Once you tell your employer, they're legally required to look into it and to deal with it. Whether it's talking with this person, making sure they understand what's appropriate, what's not, moving them, firing them, whatever they need to do to resolve the issue. They cannot legally ignore it. They can't look the other way. They can't give them a break. Okay, they have to deal with it. So, but you always want it to be in writing. I know it's not comfortable, but the other thing I want you to remember, T, is you cannot in any way be punished for doing this. Not by the company, not by your boss, not by anyone, okay? So you want to deal with that. Now, if you've done it and it doesn't change, your employer doesn't do anything, let me know, contact me. Either I can get them to do it or I can get you out of there with compensation. So T, that's what I want you to do in writing. The key, again, if it's not in writing, it doesn't exist. It never happened. So do it in writing, and any problems, if it doesn't get resolved right away, you reach me, and you can do that through employmentlawyer.ca. Again, employmentlawyer.ca. And T says, we work at a grocery store. Most of us are just cashiers. Doesn't matter. The company would still have someone, whether it's at your grocery store or maybe in head office, they will have an HR person, an owner, whoever the right person is in your workplace, okay? Whoever's above the person that's supervising you. You have to do that, okay? And you can. If you don't do that, nothing's going to change. And if you're okay with that, fine. If you want to change it, if you want to stop it, that's what you have to do, okay? But again, in writing, if you just go to talk to someone, not good. It's not going to be enough. You want to put that in writing. So let me know if there's any problems. You know how to reach me, employmentlawyer.ca. Again, employmentlawyer.ca. All right, fantastic, great question. Again, if you're just joining us for the last few minutes, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and I'm here with you answering questions. I want yours. You still have time. Okay, how about this? If you ask it now, promise you get an answer today. How's that? Promise. So ask the question, just like Vipul. Vipul says, I was fired during my probation period, but the reason, he said, it is because of your record of employment, and I haven't done anything wrong during my employment. I have everything on email, but I was never ever informed about the probation period, neither verbal nor writing. Okay, so not sure exactly what you mean about the record of employment, but here's what I'll tell you. A probation period is not automatic, okay? So you're not on probation just because you started a job. So even if you started a job, you're not on probation unless you sign an employment agreement that says that in the first 3 months you're on probation. So if your employment agreement says that you signed that says you're on probation for 3 months and during that time we can let you go and pay you nothing, they can let you go and pay you nothing, potentially. If you did not sign something like that, if you're let go and even in the first few months, you're going to be owed severance. So you can't stop the company from letting you go. They're allowed to, but they're going to have to pay you severance. And yes, even if you work for 1, 2, or 3 months, that severance can be substantial. You could be owed a few months of severance, even if you only work for 1 or 2 or 3 months. It's very common to have someone that worked for 2 months, and that person could be owed 2 or 3 months of severance. Very, very common. So, Vipul, I want you to reach out to me and let's talk about what you're owed. I want to see your employment agreement so that I can assess what you're owed. So it's not about the fact that you were let go. It's about what you're owed as a result of being let go. Okay? And to connect with me, very easy to do. That address on the screen, employmentlawyer.ca. Again, employmentlawyer.ca. Fantastic. Good question. Very common. I get people asking me that all the time. You need to call me again, employmentlawyer.ca, Vipul. Let's have that chat. Make sure you get what you're owed. Great question. I'm Lior Samfiru, the employment lawyer, live answering questions. Yours too. Let's see. Next question is from Blockboy. Why do companies lowball severance pay and benefits being with the company for 6 years. Well, why do they lowball it? Because they don't want to have to pay you as much as you're owed. And guess what? If the company lowballs, most people are going to accept because they don't know any better. So if the company is letting go 10 people and they offer all of them illegal severance that's not adequate, easily 7 out of the 10 easily are going to accept it because they don't know any better. They're not going to know that what they've been offered is not good enough. So it's not bad for the company. Like, wow, we just saved a lot of money. Over 90%, 90% of the time when someone is let go, they're offered a lot less than what they're owed, a lot less. It's unbelievably rare, let's put it that way, for someone to be offered proper and full severance. So there's a good chance if you lost your job, whatever you've been offered, not even close, which means you have been wrongfully dismissed. That's what a wrongful dismissal is. So if you're Blockboy, if you were let go, connect with me immediately. Let's find out how much you're owed so you can get what you're owed. You can connect with me through employmentlawyer.ca. Again, employmentlawyer.ca. All right, let's see. Brandon has our next question. Can my boss change our payday? Usually on Fridays, but they want to change it to Monday. Unfortunately, that's not fair. That's not nice. But legally, they could do that. Okay, if they're going to change from Friday to Monday, I know that creates problems because you may have bills to pay, so you may have to adjust that. But it's probably a change that's not big enough to be illegal. It's probably the type of change that they can get away with. Again, not fair. I wouldn't like it either. But legally, they could get away with that. There's not going to be much that you can do, especially if they give you a bit of notice. If they were to say, well, starting tomorrow, you're not getting paid Friday, you're getting paid Monday, they may be liable for any losses. But if they say, hey, just so you know, effective next month, payday is going to be Monday instead of Friday, yeah, they could do that. So Brandon, hopefully that makes sense. Yeah, let's chat. All right, let's see if we can get some more questions answered. Mary Lou has a question. Can I speak to my employer directly, as my lawyer don't really represent me? I know nothing about your matter. I don't know what issue you're having, to speak to your employer about what. If you have a lawyer, you should work with your lawyer. That's all I'm going to be able to say. I don't know anything about your matter, so I really can't say. Okay, Vipul, who was let go supposedly on probation, says, I was not made to sign any employment agreement. He just says you're hired, and then later he sent 1 week schedule, and then I started working for the week. And after the week ended, I was fired. I already have a job. Will I still be eligible for compensation? Yes, you might be, depending how long it took you to find another job. So you're not on probation because you didn't sign anything that says that you're on probation. Again, probation is not automatic. So if you want to have an assessment of how much you're owed, reach my team and I. You can do that through employmentlawyer.ca. Again, employmentlawyer.ca, the way to do that. All right, I think I've caught up on all the questions, and this is probably a good time then to say thank you. Thank you for being here with me today. Thank you for asking questions. You make this session what it is. I'm going to continue coming here, as will my colleagues, because we get such great questions, just like I did today. But if you need help, don't wait until the next time we're here. Contact us right away so we can have a private discussion. You can do that through employmentlawyer.ca, and we're looking forward to doing that. The smart thing is to have a proper discussion, a full discussion, and we can do that face-to-face. We can do that by phone. We can do that on Zoom. We can do that through email. Just reach out, and all the contact information is employmentlawyer.ca. Guys, thank you so much for being here. I'm Lior Samfiru, the employment lawyer. This was my pleasure. We'll see you all again very soon. Take care of yourselves. Bye now.